Okay, again, hi, this is Dr. Debra Dupree, Mindset Mondays Q&A with Felicia Amenta, and we bring to you hopefully the latest and greatest on what's happened in the world of workers' comp and this unprecedented world of COVID-19. Welcome, Felicia.
Oh, yes. Thank you, Debra. It's lovely to be here. I really enjoy our Q&A sessions.
Oh, that's great. Yep. We learn something new all the time, right?
Mm-hmm.
Yep.
Every day.
Yep. So a couple things here is, again, this is being recorded. You will be sent a replay, everyone. I'm going to go over the topics that we plan to touch on in the next 45 minutes. And if you have specific questions, you can use the chat room, which is available at the bottom of your screen by clicking on More, and put questions in there. In between, I'll be monitoring them, and so hopefully we'll have some time at the end or try to address them as we go along. But what we planned for today, and Felicia and I always get together the week before and just say, okay, what's happening? What are people asking about, and what do we want to focus on for today's program? So first of all, what best practices are emerging for addressing employees' underlying conditions impacted by COVID-19? What are our options in dealing with them? Number two, what challenges are being faced by employers and employees with childcare needs under COVID-19? Number three, what's happening with employees' family members who present with underlying conditions? What are the rules and regulations saying? What are some of the best practices? So we've got the employee's underlying condition, we've got the childcare provision, then we've got the family members with underlying conditions. And I literally just got off an IPM 15 minutes ago. We dealt with all of these, okay? And then what options?
All three of them.
All three of them, yes, we did. Yep, yeah. And address why the employee not being at work was a problem, okay? And then what options exist for employees unable to wear a mask or be fitted for the N95 mask when required for the job? What's happening with employees ready to return to work given their injury claim, but delaying due to fears about COVID? That was also part of the one I just dealt with, okay? And then what happens when an employee declines to sign the DWC notice of offer but continues to work? And so we've been doing some research. Felicia's brought some great up-to-date stuff, and I'll share with you sort of how I handle it, because you're going to find out the labor code's not real clear on it. So very good. I just want to make sure everybody's on board. Debbie Gallo just joined us too, so that's great. Okay, so let's get started. Felicia, from the County Office of Education, what are you seeing emerging as some best practices?
So it's interesting. What the county office did on the Hill was a survey. This was not a mandatory survey. This was an optional survey that went out to all staff as the district is getting ready to open some of their school sites. And they basically asked some questions about whether you had any concerns or felt you needed any accommodation or you had any limitation, and you could check the box on the items. And the items were an underlying health condition, issues with childcare where you had somebody at home, or children were on virtual school study at home and you couldn't come into a site because you couldn't leave them at home and they needed you to help with their schooling. And the other check the box was if you had a family at home or someone that you were caring for that had an underlying health condition and that caused you concern about going to work. And then there were some open-ended where you could add some information, but you don't have to. You could just check the box and sign it and send it in. And then they did have some information at the bottom that, of course, this will all be kept very confidential in HR. That information was obviously being used to identify individuals that might need to have a follow-up interactive process meeting or a discussion if their job requires them to come on site and they have concerns about any of those issues or they feel they cannot come on site. That's at the county office. Out in the districts, there has been, as you've noted, a real increase or rise in meetings and questions about these kinds of issues. They fall in the non-industrial realm, but Crystal and I have both seen how they're bleeding over into the industrial world. We've seen a few things, right, Crystal? We're seeing a little increase in our stress psych claims because COVID's causing a lot of anxiety, stress. They don't have COVID, but they were able to work at home completely, and now they need to come in either to Zoom teach virtually from a site, which a lot of the districts are doing. You need to come in to your classroom and the students aren't there, but you're Zooming from there. So they have anxiety about that because they're working on campus with other individuals. And then we're also seeing just an increase in requests for limitations or accommodation, or can I do this some other way? Can I be in a different position? And then some districts obviously are opening up where they have in-classroom instruction. We have many of our member districts who have already opened up in some kind of a hybrid or part-time fashion. So there's been a lot of increase in questions and need for non-industrial interactive process meetings.
Okay. Yeah. And I invited Crystal to unmute herself if she had something she wanted to contribute about that. In fact, the one I just did this morning, it wasn't a school district, but it was a public agency. The employee was just released at the end of September regarding the injured body part. But there have been some other health conditions for himself, his spouse, the impact of what's happening with that on the child's learning. And so we really tried to come in with a multimodal approach, shall we say. But basically, the IPM was good in the sense that we were able to clarify, all these interacting laws and, what had been exhausted and where we could go from there. And but to let them know that we were here to work together as a village to keep them working, because it was a good employee. But as I said, if you can't be at work, you're not doing the work. Mm-hmm. And they've already been struggling for quite a while. So we were able to come up with a plan. And what I've been noticing is that both in the writing, the research, and just working with employers, is that while many employers have that 60 to 90 days temporary accommodation, this is a great time to implement that. But to say this is only good through the end of the year, because we expect that hopefully new conditions will surface for 2021. But, employers are encouraged to be flexible, compassionate, but still be, as we like to say in my world, be brief, informative, fair, and friendly. So, you want to be fair, you want to be friendly about it, but to let people clearly know that this is no, this is no laughing matter. You got to be at work, and that's the way it is. Yeah.
One of the things that happened for the county office employees, anyway, just to use it as an example, we are, those of us that are working at home are working on a telecommuting agreement, and it does have a start and a stop time. And when we initially started this, months ago at the beginning of COVID, the time elapsed recently. And so you're right, everyone had to go through their telecommuting agreements and extend them as we're extending for those that can continue to perform their jobs at home, meaning that it is working, there's no issues, and if you need to go to the office occasionally, that's on your telecommuting agreement, what days you go to the office and what days you work at home. So, but we think that having an ending date is very important on that, right? Because it does set up to your point, your limitations, and that this is also a temporary assignment. This is not your forever job, right?
Yeah. I was reminded of something when COVID-19 first went in. I had a podcast with, defense attorney Mark Barber and Stephen Tissey from the employment law side. And, and when we planned it, and then when we actually delivered it, COVID-19 had erupted, and so we quickly shifted. And as they both said, it's like, wow, this COVID-19 in itself is something very unfamiliar, we just didn't have any knowledge about. We certainly had practices from other situations that we could readily apply to this. And so that's where even applying the interactive process to addressing some of these more complex COVID-19 conditions can be very helpful. Using our 60 to 90 day, temporary return to work provision, again, can be very helpful. And much like you were just talking about with the telecommute, people who had a real fear of coming back to work because of their underlying condition, we've been able to work out, 1 day this week, 2 days next week, 3 days the following week, so that we can build some psychological safety, but also just clarifying in an interactive meeting just what provisions have been put into place with this whole return to work effort, contrary to what was happening last spring. And so just having, up-to-date knowledge of like plexiglass and rotation and limited numbers have helped people feel a lot more secure about actually engaging in the workplace. And so I've actually set up a number of those where we're graduating people back in. Some work can be performed at home, and some work can't be, and even in one case, after going through the essential functions, an employee offered to accept a pay reduction during this temporary return to work because there were definite provisions she could not do unless she was at work, but she was going into work 1 day a week, but it wasn't enough to meet the needs because of all the backlog that already existed. So we've been pretty creative, but yeah. So, folks, I guess the message out there is that, certainly a lot of school districts have, undertaken them themselves, because sometimes it's just like with any accommodation, if it's pretty straightforward, go ahead with it, But when it does get more complex, like the one I had actually had 4 elements of what we're talking about today, all part of it was like, oh, this could be better timing, use your existing practices and approaches, and don't hesitate to get help. These are not, these are unprecedented situations. Yep. Crystal, did you want to say anything from your workers' comp perspective?
No, not at all. I think you covered it.
Okay. So Crystal's here with Athens administrator, so she sees it all there too. Yeah.
Yes. The one thing I've noticed, and I think Crystal and I both have noticed some trends that are emerging on the comp side because of what's happening with COVID. So they've been interesting trends. The one trend is a lot of our claims, medical treatment was delayed because of COVID and doctors not wanting to see them and hospitals not wanting them in and surgery centers not wanting them in. So almost all of our surgeries and a lot of our treatment, inpatient and outpatient, has been delayed. So our work comp claims are what Crystal and I would call they're dragging along. So people have actually been off work longer than they would have been without COVID because of this delay. Some employees, not all, but some employees have even further been delaying this process, right, Crystal, because they don't want to go back to work in the classroom. And so they're doing what I call putting the brakes on their work comp claim. And if you do have employees where you notice that happening, then we do need to work with the Athens claims team and the treating doctor to see what we can do. You can see that by canceling surgeries and moving dates further out. You can see that by not going in and getting physical therapy. There are legitimate reasons for this, right? They're afraid to go in and be around people. Crystal and I both, we've got telehealth on now with almost all of our physicians, and we also can do some tele-rehab. It is not as good as regular physical therapy, but if you do notice that the comp claim is slowing down, significantly, we can work on those issues.
Very good, thank you. So I'm curious to see what you're finding out, Felicia, around the childcare provision under COVID-19.
It's interesting. I've talked to a few districts who were doing some meetings with employees last week who did not have anyone their kids are not back in in-person instruction, and they are doing a Zoom school at home with their children, and they're working at home. Everybody's working at home. And so they couldn't come back and teach in the classroom. And this particular district is having all instruction. You come in, the children are not, the students are not back, but the employees have to teach from the classroom. And so they transferred her assignment to a different assignment temporarily, during this period of time. to where, because they had some assignments for the kids that are all virtual at home. So that was that creative that you were talking about, right? They actually transferred they had someone else come in and teach her classroom for this temporary period of time, and she's going to go work, stay at home so that she can do her, her kids can do school at home, and she's going to work on this virtual assignment because they had some needs there. So
Yeah.
that worked out, right?
Yeah. Yeah. Well, and I know, and maybe more than I know some, and maybe there are more than what I know of, but providing, childcare on site so, people can come back to the workplace. And I know that the city of La Mesa, for example, actually provides a day camp program for their employees so that they can work. I'm curious because one of the things that came up, and I got the permission to talk to La Mesa Spring Valley, because that's where this case was located. Because I've been hearing through some other IPMs about how parents are coming together to do sort of a group instruction so that
Right.
Parents can take turns, or something like that, or somebody who's not working, will actually, provide oversight to students who are doing distance learning. And so, because that's one of the options, because of the spouse's needs, Dad's sort of caught, between a rock and a hard place, literally, in terms of how to oversee the child's needs. And so we're going to do a little research into what might be possible as far as parents coming together for some group virtual distance learning.
And I think too, the hybrid programs that a lot of the districts that have opened up, like Grossmont High School District, they're not open 5 days a week, right? So, and Crystal, some of our districts, they're open, but they're open a few days a week. And so that allows for that daycare flexibility you were talking about. Because Crystal, haven't you seen some of the districts in your units? They're opening just a few days a week.
Yeah, some are opening 1 day a week, 5 days. Some are working, or some schools are back in each day only in the mornings for one session and then the afternoons for the others. So each district's been handling a little bit differently.
Mm-hmm. And so sometimes that lends itself to what you were talking about, is the parents going in a co-op and helping each other, or the staff helping each other. These are things that the employees have to work out, right?
So some creative things happening there too. And like Crystal said, as I've seen a lot of schools who don't have students come on that 1 day a week so that teachers can get caught up on other administrative tasks, or do some of the assessments when fewer people are on campuses, things like that. So yeah, it's been really interesting to see the broad mix of approaches.
Right.
Yep. Yeah. And so the next question, Felicia, is again with family members who present with underlying conditions. What do you want to add there that we talked about already?
So a lot of the requesting leave is a lot of the requests for accommodation. And that came in on the survey that came back from the districts. Quite a bit of in some cases, that's what the accommodation is, that they have a family member that's ill that they need to care for, and they can't be present to come into work, whether they're Zooming from the school district or whether they're teaching in-person instruction, because they're afraid of being exposed and bringing it home to this high-risk individual. Mm-hmm. And in some cases, that hasn't been able to be worked out, meaning then the districts have a meeting with that person. And in childcare, I want to say the same answer. I have seen lots of districts where there has been situations where the accommodation is that the person takes their leave, that they're using vacation time that they have accrued, or they're using sick leave time that they have accrued, because they don't have COVID and the people at home don't have COVID, but they don't want to get COVID. And that's why they want to stay at home. Mm-hmm. And in some cases, leave is the accommodation, and that's okay too, right? Yep. If you have it, that's what it's for, right? To use it when you have an emergency. Yep. And, FMLA also is coming into play here, right? Because you're caring for a family member.
Yeah. So I was able to share because of one employee's frequent absenteeisms due to a prior health condition and now his spouse's condition. He only had like 245 hours left of FMLA. And so I just stressed how important it was that he knew that and that if he actually exhausted all those 245 hours, he may not be eligible next year. And so he needed to know that in order to manage that. And I know in another situation where she had both the COVID childcare, she used her COVID sick leave, and her doctor wanted her off of work, working from home through the end of the year. Well, the nature of her position was one of those public-facing positions.
She needs to be there.
Yeah, she's already been accommodated since June, and so or whenever the employees came back to work, June or July, and so by going through all of her available leaves and stuff like that, we were able to identify specifically how many days of full pay she had left. And that if she actually stayed off of work through the end of December, she was going to have some financial consequences because everything had been exhausted. And so with that information in hand, we were able to, develop that, graduated return to work program so that she was back full time by early November, which is when her leave would end.
Right. And we always talk with our member districts about how important it is to communicate that piece. When is leave running out? Is industrial leave, if it's a work comp claim, when does the 60 days run out? Do they know? Has sick leave run out, using it with the 2/3 work comp? Are we using extended sick? When does the 100 days run out? Does it run out before the June 30 rollover? Are you going to make it? Are you going to be placed on 39-month? The employees need to know where they are. And in these non-industrial COVID situations, if you're going to if you're going to use leave, then you need to know exactly. I think that needs to be spelled out. If you're going to do the meeting on your own, or whether you're going to use Dr. Dupree to do the meeting, you still have to have a very clear, very distinct conversation about how much leave there is, right? Because you don't want to put the employee in jeopardy of running and exhausting out of leave and possibly being in an unpaid situation without their knowledge, right? They need to know up front what are the consequences of doing this.
No, sure. I mean, that's an excellent point, Felicia, and because employees don't, even though they may be longtime employees, they may not necessarily understand this interplay. One I just did last Thursday, get a long-term employee, very good in her job, but she clearly does have an underlying condition because it was evident even during our virtual meeting, as far as her respiratory condition, things like that. But she's been absolutely adamant about not being at the workplace. And it's like, well, we've already been doing this since mid-June. So you've already exhausted your 4 months. In their case, it's 120 days. You've already exhausted your 100 days of temporary leave. Not really, I mean, we can sort of be flexible, but you got to start coming back to the workplace. And she was pretty adamant about it. And so I was able to play the heavy, okay? And, this wasn't the school district that was, saying, it's like, well, these are the way the laws run. And we're trying to work together with all this and let you know, a leave of absence is an appropriate means. And so she goes, really? I didn't realize, and so we anticipate she will take that course of action now, for her 100 days of, differential pay. I think she had some vacation sick time to run out before she does that, but she is at risk. But again, she's got that front-facing position, different from the one I talked about a few minutes ago, and so that's a win-win situation because now they can get somebody in there temporarily to assist the assistant superintendent in a way that's meaningful and productive. Because right now the assistant sup is just sort of exhausted trying to do her job plus all the other stuff the other one's not doing. Right.
Right, because everybody has additional responsibilities now because of COVID. There's a lot of new things coming down the pike, like the new respiratory requirements that you have to do the fit testing for the N95 mask. The N95 mask got sent out to a lot of the member districts and charter schools without any instructions on, what are the OSHA requirements for wearing those masks. And there's some pretty significant requirements for those masks. So I had to very rush add all of those services to all of our contracts for the clinics that would do so. And then we had to send messaging out to the districts that you can't, and many of the districts had already passed out N95 masks to many of their staff, and some of them gave them to their students because they didn't know that you have to have a lot of, they are hard to wear, and there's medical conditions that preclude you from wearing them. And they have a lot of restrictions that go along with them.
Yeah. Well, this comment actually ties to what we were just talking about, as well as moving into that very topic, okay? one of the things that came up with this, case I just mentioned last week was that it's real important anytime we're doing the interactive process for any kind of medical condition, and particularly under COVID circumstances, what is the purpose of the job? The employee felt in last Thursday's case that she was doing all the job. And the reality is, well, no, and we actually went through the essential functions and identified all those front-facing areas that were going unattended or being fulfilled by the assistant sup. And say, well, what's the purpose? It is there to serve and assist the assistant superintendent.
Mm-hmm. Right.
So that goes back to the N95 mask too, is what's the purpose of the job and is one required? So what's happening with people who, should be wearing them because of the purpose of their job, but don't want to wear them?
So it's been a little all over the board. So each district has to do their own respirator program if you're going to have employees that are going to wear N95 masks, because that requires health questionnaires annually and fit testing annually for their mask to make sure that they can wear one and it fits onto their face. We have a lot of districts have custodial staff. They're not wearing the N95 masks like healthcare workers and some of our special ed, because they might be around students or children with COVID-19. They are wearing the N95 mask because they're spraying and cleaning products that require an N95 mask to help them with that. And it's been interesting though, if you have a beard, you cannot be fitted. You have to be clean shaven to wear an N95 mask because it is affixed onto your face. And if you have facial hair on your face, you can't wear them. So that's been a whole issue with some districts because the custodial staff, a lot of the male staff have beards. Mm-hmm. And if you're a healthcare worker and you have a beard, you have to shave it. That's the end of that story. If you're going to do your job, you need to wear an N95 mask. If you're going to be exposed to potentially COVID patients, you have to shave your beard. So, that was one of the discussions that happened. Do we have to mandate that people need to shave their beards that have one that don't want to shave their beard? Yeah. So who knew? That actually got into a medical discussion because a couple people went down, and some people have failed their N95 fit test, which they didn't realize that was a thing. They have underlying medical conditions that they did not understand were going to preclude them from being able to wear an N95 mask. Yeah. So that's been interesting too, because if you can't wear one, then there has to be a discussion. Can you still do your job, without an N95 mask? Or would your job have to be changed so that, because generally they're worn by healthcare workers and maybe some special ed workers that are working in with students that have COVID or that could have COVID.
Yeah. Well, I know the whole thing about, shaving a beard if you wear one. It's like, well, that's my personal freedom. You can't tell me,
Yes,
again, under the current pandemic conditions, if your job requires it under these unique and extraordinary circumstances, then yeah, that's a requirement. And the good news is that facial hair grows back. So it's a temporary.
Yes, it's a temporary condition, right? I think there was a comment in the chat, but I'm not sure if it related to that question. Deborah, I didn't know if you could see.
No, I just put one out there, just encouraging people if they had questions not on our list to make sure.
Perfect.
In the chat room, yeah. So that actually leads me to another question or a comment then, because, and I had this before before COVID started up too, is that, we do have people who have more and more respiratory conditions for a variety of reasons.
Yes.
And so not only building materials, but then also cleaning materials. And some cleaning solutions are, mandated down from state guidelines. And so what we've been able to do is to explore for when people do have respiratory conditions, and this came up in one of my cases last week, is that, working closely with buildings and maintenance or, whomever is in charge of your school district to explore what other kinds of less toxic cleansers could be used because of the increase in frequency of cleaning, and then how can it be done in a way to minimize the impact on people actually present on the job site. And so that's where having flexibility and creativity, at least, okay, this is how we've always done it, but now under COVID, we need to think about doing things differently.
Right, and because of the new cleaning requirements and a lot of the solvents and cleaning solutions we're using, I work real closely. We have a loss control team that helps on the work comp program and on the property and liability side. And Michael, who's their supervisor, has been really helpful to all the districts, because we have had several districts who are using certain cleaning solutions that require some of the employees that are using those solutions to wear masks. And you're right, some underlying conditions like asthma is one of them. In some cases, you won't be able to pass the medical evaluation to be able to wear the mask.
Mm-hmm.
So sometimes alternatives to those cleaning solutions are talking with loss control about different things that you can use. That's why I'm so glad that we have them, and it's no additional cost to our member districts to use those services to keep your employees safe and also be able to keep them at work, right? Even with those complications.
Yeah. And so a couple of things on that I'd like to add before we move to our next question then, is that this is where, for those of you who've used me, I'm always first to put out employee, you contact the Job Accommodation Network. The Job Accommodation Network is, a network filled with subject matter experts in different kinds of medical conditions. And so they are probably going to know the latest and greatest about what kinds of things will aggravate different conditions and make suggestions for alternatives to consider. And I usually do that too, not only as employee, it's your job to make changes in what you do too. That sort of goes back to the beards thing too.
Mm-hmm.
You have to contribute to a temporary accommodation in how you do things in order to keep working. And so what are you going to do differently? And that's how I was going to try to capture what have employees done to change how they do things, so we can show that they're just as responsible making the initiative too. But going back to the employee then, is that they need to work a little bit more specifically with their medical provider to provide guidance as to what can and what doesn't, because it's not just the employer's job to figure it all out, because you are asking an entire department, entire district in some cases, to make changes on behalf of one employee. But I always say, more and more we're having more people with respiratory conditions, and so it does not just make good business sense in doing things differently. That's something to explore, particularly under these circumstances. We don't think this is going to go away real fast.
No, right.
Yeah. Okay. So we talked a little bit about that, with employees ready to return to work. Is there anything else that we want to add to that question?
I just wanted to add that I think it's really important if you have a board approved JPA return to work program, which almost all of our member charters and school districts do. I think that best practice is you're using that in a non-discriminatory way, both for your workers' comp employees and for your non-industrial situations. So whether they have cancer or whether they have MS or whatever their conditions are, if you have a 60 plus 60 to 120 days, or I know some of our districts and charters have 90 to 90 days of temporary accommodated duty, you want to, if you were not using this for both, I think now you really should. You should apply it fairly to all of your employees that are disabled. And if you need a copy of the JPA Return to Work program, you can contact me, and we're happy to provide that. And in most cases, your board has approved this policy. There are some of our districts who could not get board approval, but they're just loosely applying a return to work program. But you want to do this both for non-industrial and for industrial disability. A lot of our members just apply it for work comp claims, but the return to work program is for anyone who's off work on a disability, regardless.
Yeah, and under the ADA, Americans with Disabilities Act, and the California Fair Employment Housing Act, or FEHA, that's where your tremendous financial liability fall in failing to engage. That's the most often, claim against employers, is a failure to engage, and the law will get you for that if somebody files that claim. And so I haven't heard it so much this year, but 1 to 2 years ago, there were a lot of employment law attorneys out there looking for employers who were not willingly engaging in the process, because that's actually one of the rights and responsibilities under those two laws that have nothing to do with workers' comp.
Right. And one of the questions, and I know you and I have talked about it, and Crystal and I have talked about it too, there's a lot of confusion around the letter offers of return to work, both for modified and alternative offers of return to work by the schools, and also for regular return to work. There's a lot of confusion about when those forms are given, what they're for, what happens if they don't sign them, do they have to be done at the IPM meetings? You know, there's a whole plethora of questions about those forms, and the voucher too that goes along with those forms.
Yeah, you know, and that's one reason we added it to today, because I certainly have gotten some questions on that, and I said, well, this is how I handle it, but you know, quite frankly, I'm not sure what the DWC would do. So I'll just share with you how I normally explain it and say, and I talk about it. I don't necessarily have it ready for the meeting because I'm not always sure where the meeting is going to go.
Right.
But then I go ahead and prepare it on behalf of the school district in Athens when it is work related, as part of my preparation of the IPM summary. And so I go over it. I actually show the employee, you know, on the shared screen what it looks like so they know what to expect. And just simply explain, you know, this is required by the Division of Workers Comp. Anytime an employee gets injured on the job and they return to their regular work, no modifications, if there are job modifications or if there are in an alternative job. And so, you know, the employer has 60 days to research and review their ability to accommodate, and the employee has 30 days to sign. And I certainly have been asked, well, what if they don't sign? So, well, you potentially, you know, could put your job at risk, you know, because your employer is working with you. But it then also impacts, you know, the job retraining voucher, because it was my understanding, and we talked about this the other day, is that if they don't sign it, then the employer is still on the hook for the job retraining voucher. But you said that that isn't necessarily true.
No. So some of the timeframes when we were talking, I went ahead over the weekend for fun, researched the labor code on for fun and the regulations to make sure that I had all the timelines right. And the really red alert timeline that Athens has is 60 calendar days from the date Athens receives the permanent and stationary report from all conditions claimed in the workers' comp claim from either the primary treating physician, a QME, or an AME, from any of those parties. So that 60 days starts from the day Athens gets it. And that's why Athens, they can't send you the actual permanent and stationary report because that's a violation of the employee's medical confidentiality. So Athens will cut and paste what the work restrictions are, the limitations are, or any comments in that report, because sometimes they live in other paragraphs, right, Crystal, about return to work. And they'll just send you those sections. And the red alert is we have 60 days, not from when you receive it, but from when Athens receives it, to have a meeting with them. And you can do that on your own, or you can do that with our consultant, with Dr. Dupree. And at that meeting, either you have to do the letter offer of return to work. Athens can also do the letter, but you have to call them and let them know you've had a meeting, or Dr. Dupree can do the letter offer. And the letter offer, you're right, as Dr. Dupree spoke of, they have 30 days to object. A lot of the districts have said in charter schools, well, what if we've had the meeting, they accepted the modified or alternative work that we offered them, but they refused to sign the form after the meeting. And when I did some research on the form, you're right, it says that if the employee doesn't sign the form, either regular work form or the modified or alternative return to work form, it's deemed that the employee has they are not entitled to the voucher. And Crystal, am I correct about that? I just wanted to double check since we have the Athens expert here.
Yes, so long as you give them an offer, you've done your due diligence. And if they refuse to sign the offer, then that's on them. And ultimately, from my understanding, their job isn't protected at that point.
Right, in 30 days, it's deemed to be a rejection of that offer of modified or alternative duty, or if it's regular work and they've come back to regular work and they don't object in 20 days, it's considered that they have accepted the regular work. Those are the timeframes there. I think one of the districts came up with a very interesting example where they had an IPM meeting. They did it on their own. They didn't do the letter offer at that time because I think they weren't aware that they needed to. The employee accepted at the meeting and was doing the permanent modified duty. Later on, they tried to get her to sign the form because we talked about where's the form. We need to have the form done, and the employee refused to sign it. And I think that in that case, and Dr. Dupree, you can add your comments, Deborah, but I think what should happen is you should indicate that you met and the employee accepted the offer, but they refused to sign the form, and just go ahead and send it in that way. Crystal, do you see any problems with that?
No,
Okay.
I don't see any problems with that.
And this would be something, just to have in your back pocket, so to speak, is just a simple form, date of offer, blah blah blah, and just a checklist kind of thing, so you've got clearly in the file and say employee declined to sign, and then that way you've got your documentation and it would all match up. And that's where again, whether you use me or not, I've been doing IPMs I figured out it's 26 years now. So, oh man, that's a
long time. That's a lot of IPM.
Oh man.
I want to add one more thing too. If you meet, whether you meet on your own or you meet with the consultant, Dr. Dupree, and you're not able to offer permanent accommodated duty, you know what happens? They go home and they run through the remainder of their leave. They're still on payroll with you. They're still an employee for you until they exhaust all leave and HR does whatever they're going to do at the exhaustion of all of their benefits. What Athens has to do, and I'll let Crystal add on to this a little bit, they have to provide a supplemental job displacement voucher up to $6,000, which can include retraining costs, tools up to $1,000 for a computer, and $500 for miscellaneous expenses. And from my understanding, there doesn't need to be any documentation for that. And Crystal, the timeline that I got from my research this weekend was 20 days after the 60 days for making an offer. Is that the time frame that you need to offer the voucher to the employee?
Yes.
Was there anything you wanted to add on?
Notify us that you cannot accommodate them, we have to within 20 days issue that supplemental job displacement voucher. And job displacement vouchers are due if you have more than 0% permanent disability. There's been times where some people have had no permanent disability, but work restrictions, and the employer can accommodate. And unfortunately, in that circumstance, the injured worker is not entitled to a supplemental job displacement benefit. They have to have 1% or greater permanent disability to get that benefit.
Thank you, Crystal. I didn't find that out in my fun research reading this weekend. And I guess, Deborah, you can go over the 4 things that have to be met on that modified or alternative offer, just to remind. I know everybody here is pretty familiar with the form.
Yeah. Well, a couple of things. Yeah, I certainly will. I'll pull one up real quick here, but that's again if you tie it into an IPM and you document it there, and then that way the employee's above board, it sort of makes me the driver of that process and takes the weight off of the internal people, because you still have that working relationship to manage. And so that's where a lot of people will use me so that they can still have that good working relationship, kind of camaraderie, because it's oftentimes that strained employer-employee relationship that will tend to drive employees to pursue, further claims against an employer around failure to accommodate. So it's oftentimes that dissatisfied, and that has nothing to do with workers' comp. But with that, basically the 4 conditions, if I remember them off the top of my head right now, because I didn't bring that form up, is that it has to be within 15% of the usual wages. So I always try to emphasize, yes, an employer can offer you a lesser paying position, but it has to be within 15% within California guidelines. The ADA does not have that provision. You can be offered a lesser paying position if it means staying working, okay? It also has to be within a reasonable commute of from where you where the employee previously worked. The ADA, again, is a little bit different. I think they even allow, like, if you have multiple locations, even up to maybe 60 miles away. I don't think that that's changed over the years. I just haven't had to test it for a while. I used to do a lot of work in Imperial County where employers had huge distances between, you know, and so that's where that came up a lot, but it doesn't tend to apply so much in San Diego County. And then it also has to be a regular job. It can't be a temporary or made up job. It's got to be a job that's intended to last, be a regular position of at least 12 months. And of course, then the employee has to be able to perform it, you know, as far as with their injury, whether it's accommodated work or modified work, that it's still within the employee's physical guidelines or mental guidelines too, for that matter. So these are the 4 criteria.
I tried to research a reasonable commute, right, Deborah? Because then I looked all over, Crystal, to try to find out how many miles is that, but the labor code was silent. I couldn't find it in the regulations or anywhere.
I don't know.
Yeah.
Well, again, the way it's been defined based on my years of doing this is that if I previously drove 20 miles to work, then a reasonable commute would be something within that 20 miles, for example. So it should be
similar to the prior job.
Yeah. Oh, the other thing, it's got to be a comparable shift. If you were working nights and now you can only offer a daytime position, that's actually a criteria under which an employee can decline a job or vice versa. Not that I would say you can still accept it, because I have had employees who, I had a custodian once who went from a 40-hour night job to 20-hour noontime supervisor position because he wanted to continue working and nothing else he could do. So he voluntarily took the cut and pay, and it was just well documented, and you know, and it was something he could do. But he loved being around kids, and he loved being able to continue. Or maybe it was a daytime custodian, I can't remember now, but yeah.
There was quite a bit of information in my research on seasonal work too, Deborah, and I realized that we fall into that category for our certificated and classified folks that are 9.5 and 10 month and 11 month. They would be considered seasonal because from the workers' comp perspective, we do not pay them during the summer months when they're not contracted to work, because unless, Crystal, right, they work at another job in the summer, sometimes we do pay 2/3 of that lost wage. If they can't do that because of the injury. But it's interesting, we do fall under that category of offering sometimes seasonal work to employees because they're contracted for less than a 12-month period.
Yeah. So you know, I appreciate what you did over your weekend, because you sent me a whole bunch of stuff last night, and it was like, wow, this is good stuff, you know. And so yeah. So if people are interested in you know, getting this research that Felicia offered, is that okay, Felicia, if I send them out too?
Oh, sure.
Okay. Yeah, so just drop me an email and let me know, or put in the chat box that you want to receive this, because it gives reference to the labor code and in the timeframes and things like that. So one of the things, just so people know, because it doesn't come up very often, but the voucher does expire 2 years after the date it's offered. And so if an employee doesn't take advantage of it within 2 years, it goes away. Or it could be within 5 years after the date of injury, whichever is the later. And so either 5 years from the date of injury or 2 years from the date of offer. So,
and it can't be settled. We can settle lots of things in workers' comp, and we do. We settle permanent disability. We can settle out future medical care if the employee wants to, but we can't settle the voucher, correct, Crystal?
That's correct. They won't allow us to do that. So we can CNR the claims for the medical treatment and the indemnity benefits, but we cannot CNR the supplemental job displacement voucher.
You know, one thing I want to put out there too is, as Felicia said, you know, that the interactive process as defined by the JPA, available to all member districts, is for all types of medical conditions. And I see this a lot, you know, workers' comp deals with workers' comp, but the ADA and FEHA require that you look at all medical information. And so this is where we can sometimes see conflicts between what a workers' compensation doctor might say versus a primary treating physician. And that can get a little messy. It can. And both Felicia and I have seen these kinds of circumstances, and certainly Crystal is aware of which sometimes we have to have conference calls with everybody involved and say, okay, what do we have, and where are we, and what are we doing, and you know, how do we move forward, you know? Because sometimes, and I believe, Crystal, then that, you know, if somebody ends up coming back with less restrictions per their primary treater, but that's been the most recent doctor who has most active care and treatment, that those findings could ultimately affect the workers' compensation settlement, right?
With the accommodation process, I know that you take all doctors' notes into consideration, but for settlement purposes, we typically settle on the most recent report.
Okay. So that's where we've seen a lot of confusion then in the past too, of like, well, wait a minute here, and so that can be concerning to the employer if they suddenly are bringing somebody back to work on a lesser restriction, but the claim is still being settled out at a higher level. And so it seems a little unjust perhaps, but the workers' compensation system is behemoth and slow to change.
Complicated.
Yeah. Well, I'm not seeing any questions in the chat box, but certainly we're actually a little bit over, but I can go a few more minutes till 12, I guess. If people have questions or they want more information, please feel free to chime in and let us know your questions. I do want to take an opportunity, as many people know, I started offering some classes about the interactive process because I just didn't really see a resource out there when I started this a few years ago. And so we've sort of been on hiatus through COVID and certainly revamping for a webinar version, but look for that to come out in the winter of 2021. And so it really takes you through how to do accommodations, designing, implementing early return to work programs, and then actually managing the interactive process. So for those of you new to your positions, that might be something you want to look at. And pretty affordable, pretty easy to do. And like Felicia, I remain available for questions as well, because again, being out there and seeing so many different sites and so many years of experience, I've seen a lot. But there's always something new, isn't there, Felicia?
Oh, yes.
Yeah. So anything else coming down the pike, Felicia, that you want to share with us as far as what's happening?
Everyone has to cross their fingers that we stay red tomorrow. I've been watching the news, and our unadjusted rate is 7.8. So, but that can be adjusted, as we all know, because if we do more tests than the rest of the state, cross your fingers. We need to be below a 7 tomorrow.
Okay.
So we want
everyone,
red.
cross your fingers.
We want to stay red. We don't want to go purple tomorrow we have to stay, purple for 14 days to be there. But I mean, we want to keep our adjusted rate at 7 or lower. So. Yeah.
Well, I think in that regard, kudos to all of San Diego County. I think we've done a pretty darn good job throughout all this.
All right, hospital rates down, ICUs are down. Several of the other states and counties are really, really, really struggling. So, yeah.
Well, it helps that we have nicer weather. We could do more outdoors.
Do more outside, yes.
Yeah. So, well, I want to say thank you so much for everyone who's been here today. And again, a recording will be available within a couple of days. We'll get that out to you. We try to clean it up a little bit if we need to, and we'll get it posted. Okay. Let us know if you have any questions. Thank you, Melissa. Appreciate that.
Thank you, Melissa.
Thank you both.
Bye-bye, folks.
Bye, everyone.
Thanks for joining us.
Be well.
Bye-bye.
You too. Bye.